This is the case of San Luis versus San Luis with the GR number 133743. During the lifetime of Felicissimo San Luis, he contracted 3 marriages. His first marriage was with Virginia Sulit and had 6 children. Virginia predeceased Felicissimo. 5 years later, he married Mary Lee Corwin as American citizen and they had a son. Mary Lee filed a complaint for divorce which issued a decree granting absolute divorce and awarding child custody. Then, Felicissimo married respondent Felicidad San Luis at Los Angeles, California. He had no children at respondent but lived with her for 18 years from the time of their marriage up to his death. Respondent sought the dissolution of their conjugal partnership assets and the settlement of Felicissimo's estate. On December 17, 1993, she filed a petition for letters of administration before the Regional Trial Court of Makati City. Thereafter, the heirs of Virginia Sulit filed a motion to dismiss on the grounds of improper venue and failure to state a cause of action, but the trial court issued an order denying the 2 motions to dismiss. On September 1995, the trial court dismissed the petition for letters of administration. It held that, at the time of his death, Felicissimo was the duly elected governor and a resident of the province of Laguna. Hence, the petition should have been filed in Santa Cruz, Laguna and not in Makati City. It also ruled that respondent was without legal capacity to file the petition for letters of administration because her marriage with Felicissimo was bigamous, thus void ab initio. The Court of Appeals reversed and set aside the orders of the trial court and hence the case before the Supreme Court. Issue: whether respondent has legal capacity to file the subject petition for letters of administration. The significance of the Van Dorn case to the development of limited recognition of divorce in the Philippines cannot be denied. The ruling has long been interpreted as severing marital ties between the parties in a mixed marriage and capacitating the Filipino spouse to remarry as a necessary consequence of upholding the validity of a divorce obtained abroad by the alien spouse. In his treatise, Dr. Tolentino cited Van Dorn stating that if the foreigner obtains a valid foreign divorce, the Filipino spouse shall have the capacity to remarry under Philippine law. Interestingly, paragraph 2 of Article 26 traces its origin to the 1985 case of Van Dorn versus Romilio Jr. The Van Dorn case involved a marriage between a Filipino citizen and a foreigner. The court held therein that a divorce decree validly obtained by the alien spouse is valid in the Philippines, and consequently, the Filipino spouse is capacitated to remarry under Philippine law. Even assuming that Felicissimo was not capacitated to marry respondent in 1974, nevertheless, we find that the latter has the legal personality to file the subject petition for letters of administration as she may be considered the co-owner of Felicissimo as regards the properties that were acquired through their joint efforts during their cohabitation.
Created using Powtoon.